Hi, a very good day to everyone. I am Niloy Mukherjee, Assistant Professor of English at Techno India University, Kolkata. I'd like to welcome you all to my series of sessions on law and literature, a critical perspective. This series comprises of 3 separate modules. In today's module, I would introduce you to the concept of critical legal theories. In the second module, I would move on to delineate a rather nascent field of critical legal phenomena called legal Orientalism. In the last module, I would be applying some of the concepts of legal Orientalism to the existing oeuvre of colonial and post-colonial literatures in order to demonstrate how this phenomena validates the Western epistemological violence and authorizes colonial and Western aggression on the Orient by depicting it as a lawless territory. Let me begin by talking about the interrelationship of law and literature. At the apparent level, this relationship might appear a little far-fetched because law is often associated with rigidity and literature with creativity. Law is the rule people must abide by. Literature is the saga of how people emote. However, if we take a deeper look, we can find interesting overlaps that serve as a fertile ground for research. To begin with, both law and literature concern themselves with humans and society. Literature serves the function of education, self-expression, compassion, self-searching, life, feeling, and healing. Literature inspires us and makes us dream for a beautiful world, ideal societies, and human justice. The obligation of law is to limit human behavior. However, beneath the strict language, law simply reflects the human world of experience. The study of law and literature can be divided into 2 distinct parts: law in literature and literature in law. As a reflection of law and literature, we notice the description of legal proceedings in classics and in dramas. Looking at the segment literature in law, we use literary words and literary theory to explain the multitudes of legal mandates and its cases. An interesting overlap between law and literature occurs in the domain of legal theory, especially in the arena of critical legal theories, which is the topic of my session today. Legal theory, or jurisprudence, refers to the theoretical study of law. The term jurisprudence is derived from 2 Latin words, juris, meaning of law, and prudence, meaning skilled. Jurisprudence refers to the scientific and philosophical investigations of the social phenomena of law and justice. In this sense, it embraces studies, theories, and speculations about law and justice undertaken with the knowledge and theoretical tools of different disciplines such as law, history, sociology, economics, political science, philosophy, logic, psychology, economics, and even physics and mathematics. Jurisprudence attempts to explain the incidence, existence, and consequence of law as a social phenomena through interdisciplinary research with philosophy, political theory, economic theory, sociology, anthropology, history, theology, geography, and other disciplines that contribute to the understanding of the institution of law. It seeks answers to questions such as the link between law and other social phenomena, political ideologies, economic interests, social classes, and moral and religious conventions. Also, the operation of the law as a mode of social control and the effect that it has on the persons to whom it is applied in terms of justice, as well as social, economic, and political developments. The study of jurisprudence must be seen as being the investigation of the dynamic link between law and other social facts. Critical jurisprudence or critical legal theories, which we would talk about subsequently is a strand of the jurisprudence that attempts to study the existing legal systems and provide an estimation of their real value in order to suggest necessary changes to existing systems. Now, various legal theories propounded in jurisprudence seek to look into law and justice from various interdisciplinary perspectives. Legal positivism refers to a theory of jurisprudence that states that correct decisions can be deduced from a conjunction of a statement of the relevant legal rules and a statement about the facts of the case. It considers law as a social fact constructed by human beings. Legal positivism that emerged in Britain separates law from morality and asserts that moral or immoral, a law must be obeyed unconditionally. Classical legal positivism was developed in England by the likes of John Austin, Thomas Hobbes, John Locke, and Jeremy Bentham, and was brought to the US by Langdale and Beale. The roots of legal positivism can be drawn from the times of Machiavelli, who suggested that law was an instrument of value only in exercising power, and that this is a good thing. In his book, The Prince and the Discourses, Machiavelli acknowledged that knowledge of honest and good things come from one source and one source only, the sovereign. According to Thomas Hobbes, one of the other prominent voices of legal positivism, the individual has no natural physical propensity to anything and just reacts to sensations, most particularly those of pain and pleasure. Like Hobbes, Machiavelli was convinced that man's natural state of fear and cowardice could be exploited in order to preserve social stability. During the late 18th and the 19th centuries, utilitarianism had become a very identifiable reform movement. And perhaps the most important force in forging this affinity was Jeremy Bentham. According to Bentham, the value of all laws must be tested against a calculus of felicity, whereby laws are justified if they add to the sum of human happiness, which can be calculated in terms of the greatest happiness of the greatest number. The very first sentence Bentham ever published stated that it is the greatest happiness of the greatest number that is the measure of the right and the wrong. Legal positivists have often been accused of asserting some version of might makes right as applied to law. One of the rudimentary strands of legal positivism, which was propounded by both Austin and Bentham, projected law to be the basic picture of the sovereign, issuing a command or an order backed by a threat. The later interpretations of legal positivism were forwarded by British legal philosophers such as Hart and the Austrian jurist and legal philosopher Hans Kelsen, where Austin's theory reduced all law to commands by the sovereign. Hart insisted on the variety of law, that legal systems contained both rules that were directed at citizens, which he termed as the primary rules, and rules that told officials how to identify, modify, or apply the primary rules, something that he identified as the secondary rules. Austin's work can be seen as trying to find a scientific approach to the study of law. And this scientific approach included trying to explain law in empirical terms, an empirically observable tendency of some to obey the commands of the others, and the ability of those others to impose sanctions for disobedience. Hart moved towards a more hermeneutic approach, where he analyzed the possibility of popular acceptance, whether morally justified or not, which distinguishes a legal system from the mere imposition of force by gangsters or tyrants. Kelsen applied something like Immanuel Kant's transcendental argument to law, and drawing from the parameters of the primary rules and the secondary rules set by Hart, Kelsen tried to determine the consequences that follows from the fact that people sometimes treat the actions and the words of other people, so for example, legal officials, as valid norms. Kelsen's work can be seen as drawing from the logic of normative thought. Every normative conclusions, for example, one should not drive above the speed limit of 40 kilometers per hour, or something like one should not commit adultery, one should not lie. These are some of the examples of the normative conclusions. These conclusions derive from a more general or a more basic normative premise, which is set by the sovereign or by the authority. Therefore, while drawing a comparison, it can be observed that for Austin, all legal norms were to be understood in terms of commands of the sovereign, whereas in Kelsen's case, all legal norms are to be understood in terms of an authorization to an official to impose sanctions. Evolving from legal positivism emerged legal realism, which prioritizes objectivity over sentiment and idealism in the process of legal investigation. Realism concentrates on the objective experience of the actual practice of the courts, rather than on some rules which are supposed to guide the attitudes of the judicial officials. Legal realism has expressed itself as Scandinavian realism and American realism. Scandinavian realism rejects metaphysical speculation on the nature of law and argues that the only meaningful propositions about law are those which can be verified through the experiences of the senses. American realism, on the other hand, asserts that the essential elements of law consist of actual practice of the courts and decisions of judges rather than rules in books. Realists hold that until a judge pronounces a decision, we cannot be sure about the law or its application. Therefore, statutes in books can at best be considered sources of law, but not law itself. The evolution of the critical legal project marks the continuation of the postmodern spirit in the sphere of legal studies. Of the different voices that left a lasting impression in the modern and the postmodern age, Foucault and Nietzsche features as the two most prominent ones. Friedrich Nietzsche, his intellectual legacy, is founded on the concept of the absurd. In his book, The Will to Power, Nietzsche suggested that his legacy to the modern world was its pointlessness, its nihilism that characterizes modernism. Much of the contemporary discourse on critical legal theory owes its intellectual heritage to Nietzsche. Nietzsche was fascinated by the power of language, particularly its ability to destabilize as well as stabilize meaning. Central to Nietzsche's thought is the desire to disrupt order and cherish its inconsistency. It is only in conditions of disorder that the creative will can flourish. And we as individuals can only assert ourselves against the prescribed order if we can create conditions of disorder. While despising the Prussian state, the state of Prussia, Nietzsche asserted that laws existed to prevent self-expression, and it is a reason which provides an illusionary justification for this suppression. It is only when we come to appreciate that all laws are simply a jumble of words coined by someone else and which we can recast in our own image, if we have the courage, only then can we become truly free. Nietzsche claimed that the justice of modernity, the logic which was shared by Socrates and God, is always their justice, not ours. Law must be rewritten so as to overcome the illusions of universalism. For Nietzsche, law is itself an illusion, something which exists in our aesthetic imagination and nowhere else. Its authority, as symbolized by the court, is accordingly equally illusory. For Nietzsche, the court is the literal mouthpiece of the state, and it is through the court that the state articulates its lies and illusions, an idea which is replete in the works of Franz Kafka as well. A decade later, Michel Foucault identified law to be the expression and exercise of power. Law for him evolves as a particular, merely aspiring for an universal application in an attempt to justify itself as being somehow normal or right or natural. According to Foucault, the very idea of justice in itself is an idea which in effect has been invented and put to work in different societies as an instrument of certain political and economic power. So law becomes an instrument of a political and an economic power. In his book, this seminal book, famous book, Discipline and Punish, Foucault observes that the complexities of modern life forces of a modern man or a woman to sacrifice a measure of freedom for the smooth functioning of the government, that is necessary, something that Rousseau also talks about, ages back. For the modern man, his expectations are carefully controlled by the consumer society in which he lives. And this has emerged as the classic example of what Foucault terms as a disciplinary technology. Modernism is characterized by a science of government concerned solely with expediency, convenience, which no longer aspires to realize perfect justice or save human souls, but just seeks to govern society in such a way so as to maximize its own efficiency and to maintain social stability. So there are the only two ends towards which the modern government works. These are the two ends towards which the modern government works: to realize this nation state and to maximize its efficiency. In the modern society, Foucault identifies certain institutions like the prison, the school, the military camp, the hospital, that he defines as the micro centers of power, which are responsible for overtly dispersing the control of the sovereign in various ways. Discipline the body, discipline the subject in order to enhance political control. Law is merely one such microcenter of power, directed to arrange things in such a way that through a certain number of means, such and such ends may be achieved. Thus, Foucault identified modern law as merely an instrument of economic ideology. The role of law and the disciplinary processes of prisons, police, and so forth are all dedicated to promoting the ethic of the modern political economy. In a very real sense, law therefore becomes nothing than the handmaiden of politics. Moving on to the next slide, critical legal theory. Yeah. So drawing from the ideas of Nietzsche, Marx, and Foucault, postmodernism developed a deconstructivist spirit which critiqued and questioned the written discourse, including law, and from this evolved the project of critical legal theory. This movement that emerged in the US in the 1970s offered a critique and a radical alternative to the established right-wing legal positivist theories which were propounded by Kelsen, Hart, Dworkin, Rawls, and Finnis, something that we have already discussed on. Critical legal theory bases itself on the premise that law and justice is not innocent of power dynamics and politics, and established legal theories are biased to those in power, thereby acting as mere instruments in the hand of the powerful to victimize the powerless. Voicing the opinion of Nietzsche and Foucault, critical legal theorists suggest that law formalizes oppression, makes it respectable, and indoctrinates people to accept it. Drawing from Marxism, critical legal theory argues that law, at least in the way it has historically developed, is a system of domination. Critical legal theory addresses issues such as the fundamental contradiction within society, the need for society as well as autonomy, the process of alienation by categorization and reification, the denial of the value neutrality of law, and an alternative world of critical legality. These critical legal theorists, however, do not advocate that power dynamics can altogether be eliminated from a society, but they believe that as an attempt, it is necessary to thwart further inequality of power. Peter Gable, a vocal proponent of critical legal studies at San Francisco University, radically upholds the proposition of getting rid of law, which he calls an imaginary form of social cohesion. Various other schools of thought emerged as strands from critical legal theory, such as the postcolonial legal theory, feminist legal theory, third world approaches to international law, and others. Postcolonial legal theory refutes the liberal positivists' claim to the objectivity and universality of law, things which were claimed by the legal positivists, and asserts that subjective knowledge about the powerless is manufactured by the powerful through epistemic authority, through their capacity to create knowledge, and it defines the powerless, and this created knowledge, created discourse, is later claimed to be the objective truth to define and constrict the powerless within set definitions. Therefore, the question of being legally correct becomes nuanced, with law being one of the apparatuses of the dominant group. Thus, post-colonial theory provides tools for analysis of the dynamics of post-colonial imperialism, in which law and history have been central. It aims to mitigate the asymmetrical power relations and injustices of material practices, which still continue to frame emergent legalities and legal consciousness. As an offshoot of 1970s, here I've moved on from critical legal theory to feminist legal theory. Feminist legal theory emerged as an offshoot of feminism and critical legal theory. Feminist legal theory began by addressing the materiality of oppression against women with a platform of reforming the law, but progress to transforming fundamentally the nature of legal knowledge. In the 1970s, activists argued that for all legally relevant proposals, purposes of the feminists, men and women were equal and should be so treated by law. By the 1980s, feminist scholars undertook to analyze and evaluate the legal structures that retarded justice for women instead of promoting it. Thus, feminist legal theorists began by arguing simply by the inclusion of women in all social practices as they stood, and progress to forward a critique of those practices and legal norms. Today, feminist jurisprudence is focused on law in three distinctive ways. First, to identify sources of bias and injustice within it. Second, to find ways to use it as a means to promote justice for women in other institutions and social practices, social spaces as well. And thirdly, to identify and overcome devices of denial, subversion, and containment that pose barriers to the reform. Critical feminist theory, feminist legal theory, and the various critical race theories offered different examples of social instances in which legal outcomes were structured favoring the dominant group. Focusing on the subordinate position of women and racial minorities in society, the theorists analyzed the various accounts of domination which existed for the self-interest of the dominant groups, that is, the males, that is the group of the males, the whites, and the various other dominant, subversive categories which existed in the society. Now, I'll be moving on to the next section of the third world approaches to the international law. This emerged in 1997, and it seeks to transform international law from being a mode of inequality and oppression to being a mode of equality and emancipation that would be freed of the first world ideological bias and provide truly global justice in terms of gender, class, ethnicity, and religion. Thus, in this module, we observed that while through traditional jurisprudence, legal positivism aimed to establish a foundation in reason for actual legal systems, critical legal theory and the allied schools of thought which evolved out of it denied the possibility of discovering a singular universal foundation for law based on pure reason and objectivity. I'll repeat this sentence once again. I presume this is quite important. So in this module, you observed that traditional jurisprudence, legal positivism, aimed to establish a foundation in reason for actual legal systems. Critical legal theory and the allied schools of thought which evolved out of it denied the possibility of discovering a singular universal foundation for law based on pure reason, logic, and objectivity. Rather, they focused on exposing the whole enterprise of jurisprudence, which according to them operates merely to administer a spurious legitimacy on the authority, the sovereign, its law, and the legal system. For the critical legal theorists, logic and structure attributed to law rose out of power relationships of the society. That is, law is not innocent of politics and is often reduced to a tool of the powerful to oppress the others and maintain their place in the hierarchy. They refute the claim that the liberal legal theory is politically neutral, rational, coherent, necessary, and the objective way to resolve conflict, and opine that there is a conflict-ridden structure beneath its objective exterior, an exterior which conceals the political judgments and power structure within the law. It is arbitrary, contingent, unnecessary, unidimensional, and profoundly unjust. With that, we come to the end of this session today. In the next session, we would go into discuss legal Orientalism as a particular phenomena discussed in the arena of critical legal theories. And that'll be all. Thank you for your patience.